If it ain't official Dana J, Prima Donna News, I don't even want to see it.
Say you love it, what you gon' do now? Hope you're ready, cause I'm really about to put it down. Girl, you know that I will never disrespect you. We love tomorrow, but tonight I wanna spank you. That ass count, gotta make it last now. Start off slow, then I'ma beat it up.
I know that there's more. More for you, more for us.
Children, rain all night long. Didn't it all, didn't it all, oh, my Lord. Didn't it rain? Didn't it rain? Children, rain all night long. Didn't it all? Didn't it all? Oh, my Lord. Didn't it rain?
You can't run from it. You can't deny it. You can't pass it off. It's your call. God knew what he was doing. He knew who he was calling. And he expertly and intricately detailed every aspect of your life, your being, your persona, your psyche, your physicality, everything about you, from the texture of your hair to the color of your eyes to the way that you laugh to the fingerprint on your thumb. Everything is connected to your calling. And until you walk into the fullness of the thing that you were created for, you will find yourself frustrated. You're called.
Gentlemen, may I have your attention, please? The show starts in 10, 9, 8, 7, 6, 5, 4, 3, 2, 1, go.
They say this is a big rich town. Oh, I just come from the bonus part. White like city lights, I gotta make it. This is where it goes down. I just happen to come apart. Legal or illegal, baby, I gotta make it.
Check. Let's go. 1, 1, 1, 2. They say this is a big rich town. Yo, something unthinkable just happened. Shout out to everybody that's here. I didn't get to send it out to everybody, but good God, I had to get this started. Young Thug lawyer was just arrested in court. So what I'm going to do is I'm going to show you him being arrested. Shout out to everybody that's here. I'm going to show you him being arrested, and then I'm going to take you live into the courtroom of what's going on, but I'm going to rewind it back some, so it's not going to be as it is going on right now. I'm going to rewind it back some just for y'all. But check this out. This is crazy. This is really crazy. When I say crazy, I mean this is really, really, really crazy. Like, oh my God, crazy. Check this out. Here you go.
Would the court afford me 1 moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right. Yes, sir, you certainly may. Mr. Williams does not wish to go forward without me being here. You are removing me against his will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people. I've denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for the next 5 minutes.
Whoa. Now, I'm going to take y'all back. Check it out. We going to rock out with it. Here you go. I'm going to take y'all back some. Check this out.
Covered by work product. There's only one way you could have gotten it. So I'm going to ask you.
Right, Michelle. Still standing on business.
I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6. I know what the rule says, but here's the thing. Well, I'm just. But in order, you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. I understand. I don't want to be held in contempt. And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened. Sir, that's a whole separate issue. And that's why ex parte conversations are recorded. Why would it be ex parte? You're acting like it's ex parte under seal. It's ex parte. It's ex parte because
what the
that's
hell?
What the state asked me to do. It's just like when you asked me for an ex parte conversation.
Come
you never
on.
asked the Honorable Court or any court to meet with me and a witness. Sir, you're straying off the issue. I'm not. The issue is how did you get this information? I understand the issue.
You didn't ask Ms. Love how she got information.
What I'm trying to ask you is, if you look at comment 5, this is how I understand the law. You cannot violate something and then use privilege. Okay? I'm not violating anything. Okay, but that's why I'm saying, how did you get information? But just listen to what I'm trying to tell you. You're threatening me with contempt. Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't. Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not sum and substance, but I'm telling you I can't do that under the bar rule. All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it. You can't do that. Yes, you can, because I have an idea how you got it. Well, your idea. I have an idea how you got it, but that's improper, sir. Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence. I don't want to hold you in contempt, but this is that serious. Judge, you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, but when Ms. Love did it, you ain't do all this.
Do whatever you want.
Hold on.
5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor,
this is crazy.
This is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief, from whom? Part of it. From whom? Well, I'd like to get the substance first, and then we can. Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking about?
But anyways, I'm not going to have
information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay.
Why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon
bust it open, Brian Steele.
Well, I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not when that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read the case, I'm assuming you read it. That's what it says. And you did it supposedly.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
And you can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we
that leads to be told. But
right now, we don't know
Mr. Steele,
why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right under the Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
you've already said that. You've already said
Georgia Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Lowe.
And Your Honor, and I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Lowe.
Okay, excuse me.
Okay. All right.
She is so ignorant. I do not like her.
Your Honor, I am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was...
That's bull crap. You was there.
...contained within ex parte conversation. Not only was there an ex parte communication between that we requested as the state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
Wait a minute.
The state read
What?
The case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So
this is wild.
Making the next set
what
of
up, y'all?
assertions, I would need to know how that information was made.
Hold on, I'm gonna pause that for a second. Steele don't need to tell the judge anything, nor do he need to tell the state anything. The judge broke the rules. The judge had a private conversation with someone that's supposed to have been taking a stand against Young Thug, right? Or Jeffrey Williams, right? So in Georgia, a judge can't talk to witnesses of either the defense or the prosecution. A judge can't do that. At that point, Mr. Steele was saying that a judge was also being biased, which is coercion in the state of Georgia. That's part of the Georgia Constitution. However, the problem that I'm having is he held Brian Steele in contempt and locked him up in court. But this tall, raggedy ass prosecutor that's standing right there, Miss Love, and I ain't cutting nothing. This lady she had her investigators coercion and trying to flirt, well, not trying, but to flirt with people to try to turn against Young Thug. She inducted herself into the case, into Young Thug's case, and the judge just let her say, oh no, don't worry about it, but don't worry about it, and we're going to continue. No, she should have been held in contempt of court. She should have been held with tampering with a case, and she should have been off the case. But the problem is, if she get off the case, if she be put off the case, and the case is over with. So now here's my question. Who's paying Judge Glanville? And I'm going to be honest with you. At first, because I supposed to have a case going in front of Judge Glanville, I am so happy I do not have to go in front of this man. At first, I didn't understand it, but now I understand. God do things in decency and in order. But this right here is out of order. Let's get back to this.
Privy to them, to counsels for the defendant. We did not act inappropriately. or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's quest, I guess it was for Mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
Oh, no, don't strike none of that. Hold on. What?
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding...
Hold on, time out. Judge Glanville just badgered Mr. Steele of where did you get that from, right? But he didn't say nothing to Ms. Love about the people that she was said that I don't feel comfortable saying. So hold on. This 2-tier justice system. If Mr. Steele gonna get badgered about where he got stuff from, Ms. Love should get badgered about who she is afraid or not comfortable with saying their names in an open court. Right is right, wrong is wrong. Come on.
Regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
You know what? I wish I would have got my Rule 22 for this case. I did not want to cover this case because I'm close to the people involved. I wish I would have did my Rule 22 for this case. This is crazy.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers.
Hey, B. White.
Regarding a matter
What up,
that
Chris?
has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right.
This is crazy.
Sure.
And, Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
Let's go, Adams.
He has 2 attorneys.
Okay, yeah, he does, but...
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received.
Let's go,
and
Adams.
the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial.
Stand on business.
And I'm telling
yes.
the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right,
and frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also,
you got to hold everybody. There we go.
I didn't ask you.
Yeah.
Stand on business.
I'll leave it at that. Okay.
Hold on, Glanville. You ain't locking nobody else up?
What is it, Mr. Sharp?
Hold on. What's going on?
As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial. First and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, I'll
Oh!
Okay, all right.
Oh!
Okay, all right.
Good afternoon, Your Honor.
encouraging Matthews here on behalf of Mr. Marquez.
Okay.
We are also adopting all the arguments that we made.
All right, sir.
Adams, by Attorney Max Sharp, by Attorney Phyllis Weinstein. We also we were here the appropriate time, and when the court did come out, we were not made aware that there had even been an communication that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on, even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. D. Williams? All right, thank you, madam. Motion's denied. Mr. Garner? Okay, so noted. All right. Okay, Mr. Steele, last time. Who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
If by that point we'll get started and resume the trial, Your Honor.
Yeah, we're going to continue. I'm not caught nothing.
I'm not going to participate in the trial without the Steele and
You don't have that luxury at this point in time, sir. You don't. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue that we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir.
No,
yes,
that's
you
y'all
are.
extorting the court.
I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever, this morning that.
If there is any
Hey, Amaton.
accuracy to some of the information.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay, and
Miss Love won't tell you who she's scared to say anything about. Come on, man, you biased as hell.
And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety.
Come on, man.
No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
This is wild.
Your Honor, would the court afford me 1 moment?
I will go get the judge oath of office,
regarding the appropriate,
and I will definitely file charges against the judge in district court. And then I will push for the judge to be removed for this to be a mistrial.
May I say one thing, Your Honor? Yes, sir, you certainly may. Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people. I've denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for the next 5 minutes.
At this point, he want to go into recess because he want to try to collect his thoughts, but he's also trying to change jurisdictions. This is what I've been telling folks about. And when judges abruptly call for recess, they are trying to recollect their thoughts and change jurisdictions and come with a different approach. At this point, there's no way the court can move forward. If none of the lawyers is willing to move, the court cannot go forward at this point. But the judge is trying to make it go forward. Nah, man, you can't do that. That's against the Constitution in Georgia and the Constitution of the United States. This is crazy. Hold on, I'm gonna get past this. Because remember, I told you I took y'all back. So I'm gonna get past this. Hold on, let's get back to it. Hold on. This is wild. Fannie Willis is trying to make sure she do any and everything and to make sure a thug go to jail for all because Peanut got killed. This is crazy. This is crazy. This is the hand of Fannie Willis. And I say it once and I say it again. In November, Courtney Kramer is the only way out. We need Fannie Willis and her team out of Fulton County.
Is Mr. Adams in the hallway over there? Could you get him, please?
That part, and Ms. White, he bold to do this on live TV. This is bold. Courtney Kramer, and remember what I'm telling you, Courtney Kramer is the only way out. Fulton County will be held under hostage and under siege if Fannie Willis stay as the district attorney in Fulton County. Her and her team need to get the hell out of Fulton County, and I mean that. Y'all can go do y'all research, but Courtney Kramer is the only way out. Oh, yeah, you got a problem now, bro. You got a problem now. You got a problem. Because now the lawyers refuse to come into your court.
Wait.
Uh-oh. If Mr. Adams was smart, don't come in there. Because, see, he want to put it on record. No, but don't put it on record now. No, if I was Mr. Adams, I'd leave. I don't know. You got to look up your constitutional thing, Hammer Time Funk. Each state have their own constitution, so you got to look it up. And the bad part about it is Judge Glanville is the chief judge of the court down on in Atlanta. This is crazy. This is crazy.
Just hang tight, sir.
So hold on. How can Ms. Love announce that Mr. Adams is present? Are they working together? What the hell? This is crazy. Right, busy mom. This judge is really dirty. And oh man, I shouldn't be saying that because I gotta go down in that courtroom. Jesus Christ. They already said I'm part of the enemy because I rock and with Harrison and Donald Trump. But now they really gonna call me the enemy. But my thing is I stand on truth. I stand on principle. And I stand with Mr. Adams and Brian Steele. If something crooked, call it out. That's what they get paid to do. They don't get paid to help send nobody to jail for nothing.
All right, Mr. Adams, let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and you have done more than a yeoman's job of representing Mr. Williams, and I don't doubt that that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. Hold
on for a minute. I'm gonna pause you for a minute. Y'all remember when I told y'all, whenever you going against a judge in a court and you don't go across the bar, this right here, right, and this opening is called the bar. That's called, this right here in an open cap is called the bank. And you don't go past the bar to go to the bank because right where Mr. Steele is standing at is called the shore. That's the safe zone. If he crossed that, then that means he gives jurisdiction into the judge and to the state. At this point, he can challenge anything that come out the judge's mouth. I just wanted to show y'all.
An appellate court will review my decision for abuse of discretion. So I'm going to direct that you go, that you continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you to do that and continue to do that. But Mr. Steele put himself in this particular position.
Hold on, wait. Did y'all hear what the judge just said? Did y'all hear what the judge just said? Hammer Time Funk, no, New York is not deliberating Hunter Biden gun charge. That's Delaware that's doing that. That's not New York. But did you hear what the judge just said? So he pretty much gave up that he's already going to have a guilty charge on Young Thug. Because Why would you, in the middle of a trial, jump out and say, well, the appellate court is going to look at, man, I'm gonna let y'all hear it. Go ahead. I'm gonna let y'all hear it. Check this out.
All right. Mr. Adams, let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and you have done more than a yeoman's job of representing Mr. Williams. And I don't doubt that that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. And an appellate court will review my decision for abuse of discretion. So I'm going to direct that you go, that you continue to represent Mr. Williams. You can consult with Mr. Steele.
Time out. Why would you say an appellate court will review my decision for abuse of discretion? Hold on. At this point, the case don't need to go further. At this point, you just said, okay, he's guilty. So instead of making it a circus and letting it continue, just go ahead and say, okay, Jeffrey Williams guilty. And then let it go to the appellate process. You just gave up the whole play right there. Man, listen. I urge people, if you're living in Fulton County, and if Fannie Willis is successful on defeating Courtney Kramer, which I pray she ain't, get out of Fulton County. Better yet, get out of Georgia. Because this is the right hand of thumb. We got a judge that's biased as hell. I can't say what I want to say, but biased as hell. So check this out.
Any breaks or anything such as that, I'll allow you to do that and continue to do that. But Mr. Steele put himself in this particular position in terms of all these. I'm not asking him for any other, or you for any other information that might be privileged or any other conversations, but I need to know who told you, because that then drives other things the court needs to probably do. So he's the reason as to why we're here in this particular circumstance. So if you or he or want to disclose to me who told you that, I'll be more than happy to reconsider.
I know Mrs. Steele will not. I also will not. And I respect this court. I respect that the court has to do whatever it believes appropriate, but I would ask that the court also respect my representation of Mr. Williams and standing for him when we believe that there's been a violation that affects his right to a fair trial, and we believe that is the position that we're in. And I would respectfully decline the court's order for me to continue forward.
Your Honor, may I address the court? Thank you. Your Honor, there are two things at issue here, and one of them, Your Honor, is that...
Can I ask of the court how it is that the state has any position in this particular conversation between the court and myself?
Before we recessed, Ms. Love said that she was going to research this ethical issue, because it is an ethical one. So just much like you could add to it, I'm asking the state if they wish to add to that as well, sir. Okay?
Thank you, Your Honor. Your Honor, we believe that there are two matters at issue here. One obviously is Mr. Williams' right to counsel of his choice during the trial of the case. We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial. We believe that it will need that so far this issue alone has needlessly delayed the trial of the case, and we believe that it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask that the court, notwithstanding the finding of contempt, allow both Mr. Williams, Mr. Steele, and Mr. Adams to be present while these proceedings are going on and while court is in session.
I think that would be appropriate under the circumstances. And Mr. Steele, certainly I can inquire about before the end of the day if he wishes to disclose that information that I've asked him, then he certainly purges himself of that contempt. So yes, that's fine. We'll go ahead and do that.
And the second thing that I wanted to put on the record is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may finish, the matter that the state requested an ex parte audience with the court regarding was a matter to which no one to my right was a...
Hold on. What up, Tyree? Hold on, wait. How did Mr. Steele perjure himself because he didn't want to tell you how he got the information? That's not perjury. He didn't come on there and say, oh yeah, I got this information and I got it from such and such and such. And then when you come back and ask him something else, he changes his mind. No, man, that's not perjury. Lord have mercy, Jesus Christ.
Party. It was a civil contempt matter, and the parties towards that civil contempt, the state, which moved the court to compel someone to do a thing, the court compelled, and the state said, Your Honor, we're asking if the court, if they don't comply, that the court hold that person in contempt. That was a civil contempt matter. Nothing substantive was discussed. Everything was recorded, and the representations made, at least by persons who were present to the state, is that when questioned or queried about it, is that that person was told or asked whether things occurred, and that person relayed that no substantive communication took place during that meeting.
Bullshit.
So that is the second matter. And first and foremost, we just ask that the court, again, allow both counsels for Mr. Williams to be present when court is in session so that we don't delay these proceedings further.
All right. That's fair enough.
Thank you.
Okay. Mr. Sharp?
The ability for the state to paint themselves as the victim constantly in these matters is unbelievable. We are the aggrieved party.
Sir, we can't hear you.
My client, Shannon Stillwell, and these other young men sitting here as defendants are the aggrieved parties. We were not present. I would like to reiterate.
But here's the problem. Here's the challenge, Mr. Sharp. Here's the challenge. You got the information in a way that was not lawful to begin with, sir. That doesn't alleviate the information or make it less valid or invalid. So, because we record these conversations so that they can be reviewed later. We didn't have any conversations that were not recorded. And if you heard of other conversations that were made, I don't know how you would have gotten them otherwise, because somebody had to tell you.
Okay, well, all that's...
Wait a minute.
Like I said,
Wait a minute. But Judge, you can't be in that type of meeting. That's the problem.
If and when the case gets reviewed, an appellate court will make those decisions. But at this point,
my client is the aggrieved party. He was not present.
Hold on, and he said it again. If and when. So now you know the outcome of the trial. Young Thug and his crew gonna be found guilty. Now you know the outcome.
If that violated his Sixth Amendment right to be present.
Okay, and that's your argument. Sir, that's your argument. That's your argument.
One other thing, Your Honor.
That's your argument.
All I'm asking for is some sunlight. Some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not sun. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Miss Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that's the sum and substance of it.
We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Okay. Well,
So
at this point, I'm, like I said, I need to have a little bit more information in order for me to kind of make some other decisions in this case. Not saying that you may or may not get that information, but at this point, there was nothing that was improper about in the ex parte conversations. The court's more concerned about is the disclosure. So, and
I understand the court's concerned, but as the counsel for Mr. Stillwell, my concern is the meeting that he was not allowed to be present for.
okay, all right. Thank you, sir. Are you going to repeat the same thing again? Oh, let's try not to, because the Harvey rule's in effect. I understand everyone's opinion at this point in time.
Judge, the only thing I want to say, and to not be repetitive, but on Friday, Your Honor, this particular witness came in, he pled the fifth, his lawyer was present, his lawyer stated to Your Honor that he had spoken to his witness, his client, and he stated that the witness indicated that on Monday, he will also be saying that he will plead the fifth. And then, Your Honor, there was a 2-3 hour span this morning, and then he comes on and he says, I'm going to testify. That's why I believe in the application Huey that the transcript is important.
Okay. Thank you, sir. All right. Let's get Mr. Steele out, please. You can tell him to put his tie back on.
What have I told y'all and before? I told y'all the judge would do anything to present a scare tactic. Now that none of them lawyers are scared, nor are they biased, nor are they moving from their stance, look what they said. Go get Mr. Till. Mr. Steele. He can put his tie back on. No, you held them in contempt. So now Mr. Steele can turn around and sue and the judge in his public and private capacity.
And then we'll go ahead and get started at that point in time, okay?
Got to change jurisdictions again.
is been brought to court suggestion that you be here until when we've, in all open sessions of court and until we finish for the day. So I'm still going to hold you in contempt. You can purge that contempt by just telling me who it is that told you this information. That's all I need to know. But at the end of today, I'll ask you that question again today. We did not take up any business in your absence, other than Mr. Adams eloquently saying that he was not going to go forward without having you present with him. So, and him not wanting to divulge who the information came from either. So, with that, sir, we're going to go ahead and continue. All right.
Ask a question.
Yes, sir.
Did the court order the transcript that we can see it and have a hearing and call witnesses?
No, I'm not gonna order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that. I don't believe at this point in time it is the court's understanding of the ex parte conversation that the disclosure is the more troublesome remedy. If I did something wrong, then certainly that can be reviewed, but I'm not at this point in time going to release any of the transcript in terms of what may be disclosed or that was said in Chambers ex parte at this point.
Well, I was told based upon information belief that it would affect his witnesses' testimony in front of the jury, because I was told based upon information belief that depending upon how the day goes, he may go home or not, depending upon his testimony. I'd like to know what that's about.
I don't know, Mr. Steele. I don't know. I mean, that's why I would like to know who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. I don't.
So I would like to have
You lying now.
The court as a witness, with the DAs as a witness, with the deputies as a witness, with Mr. Copeland as a witness, with his counsel as a witness, court reporter, transcript. And Judge, I'm not trying to be harmful.
Mr. Steele, I think that you're running a very thin professional responsibility line. I don't think you have cover at this point in time. I think you're blowing your coverage at this point, because I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So, I mean, but that's beside the point. At this point in time, we're not going to argue about that right now. I just need the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said. I want to know who told it to you.
And I'm making it based upon information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time.
You're holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How could something, I'm not trying to be obstruction, but how could something be attorney-client privilege if it happened before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem.
I don't.
I mean, like I said, I don't know what was said to you. I don't. So
This is
Right, Nikki M.
Well, that's improper at this point in time.
Why?
Because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And then you turn around and you say, well, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
Judge Glanville, you know you on live TV, right?
Part of the trial.
It's not, well.
Has a right to be at, and I'd like to exercise.
It would be just like if you all in the past have had ex parte conversations with the court. And I won't say about for what. You and Mr. Adams and others. That is your right. And that little period or that little conclave of discussion with the court protects you and protects the system. It's recorded and taken down. So if it needs to be reviewed later, it gets reviewed. But you have made something out of it that where I'm kind of at a disadvantage at this point in time. So, because I didn't invite you into that particular proceeding, and I don't think you had a right to be there.
Whoa. Whoa. So pretty much the judge is admitting that he was in a secret meeting with a witness that was sworn in, the DA, the prosecutor, and the judge. Oh my God. This is corrupt as hell.
Okay, well.
There's a witness testifying who met with the court and the DAs. That doesn't concern us?
Your Honor, meaning
the defense?
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna keep continuing to discuss.
Yeah, he nervous. He real nervous.
The transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may be privy to or may have been disclosed to you, they're troubling. They are. That's why I've got to find out who it is that disclosed that information. So
no, you don't.
You have the keys to your.
Listen, if it ever come out who disclosed that to the defense, that judge is going to prosecute that person like no other. No, don't tell him nothing. Keep him on eggshells.
Your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you, but I do need to know who told you.
I say Miss Love told me now.
So if you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then, I'll unfortunately have to look at and waiting to get that information. So you can let me know.
Did the court put this in order?
In terms of what, sir?
I suppose contempt.
Yeah.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this.
Whoa.
You will go into custody at 5 o'clock today or whenever we finish if you don't tell me what that is. Tell me who that is. This is criminal contempt. I have asked you a question related to these particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not.
Yeah, Glanville need to get off the stand.
Important.
Yeah, he need to get off the stand.
It is important.
Okay. All right. So think about it. All right.
Can I just, last thing, going forward, over objection, because I believe that we're entitled to these information, especially with this witness.
All right, sir. I'll note your objection. It'll be a continuing objection for the time being. And I may make some other remedies depending upon what information I find later. Okay? All right.
On behalf of Mr. Steele, I'm going to review our Brady demand for any Brady material that came out from any conversations with Mr. Copeland, between Mr. Copeland and the district attorney's office this morning.
All right.
Jesus.
Yeah, bring him out, please.
Hey, Mary Dukes. Look at Rich. LT back in the gym. What up, Lex?
That's fine.
Nikki, you right. Everybody nervous.
Come on, yours, please.
Spinning around in the chair. Hold on, yo. What the heck? I don't mean to laugh, but this is a circus, man. That's what I'm thinking, Nikki. He like, I ain't trying to do this.
All right, thank you, sir. Ladies and gentlemen, please be seated. All right, Miss Hilton, go ahead now.
Can you hear me? Can you hear me? When we left after court, I'm going to approach you with some items. Your Honor, may I approach the witness?
You may have shown those to counsels already?
Yes, this is what they saw right before we took lunch. Mr. Copeland, I'm going to show you what's been marked as State's Exhibit 350Y, 351Y, 342 Yankee, and 356 Yankee. Can you take a moment and look at those pictures? Please look at those pictures.
Do I have to look at them?
Yes. I'm going to start first with State's Exhibit 350 Yankee. Tell me if you recognize individual in State's Exhibit 350 Yankee.
I recognize myself.
Okay. Do you recognize anybody else in 350 Yankee?
Myself.
Do you recognize anyone else in 350 Yankee?
Their face is covered up.
Okay. Do you see someone's face who's not covered up in 350 Yankee?
Yeah.
Okay. Do you recognize who that person is?
I can hardly tell.
Okay. Is that Shannon Jackson? Your Honor, at this point in time, I'm turning to impeachment.
Oral, sir.
I'm also going to object with this altered photograph.
Your Honor, it's based upon the court's previous rulings.
Not based upon it's not.
Let me see it. Can I see it, please?
We've never discussed these photographs.
Chris, do we in 350?
As well, if you want to see the original.
Has 350 been admitted already? Okay, all right. Oh, you just so you're just showing him at this point in time it's not been admitted, Ms. Hilton? It has not been admitted. Okay, all right. You have any further objections, sir? What's your objection, then? No, that's not an objection. What's the basis for your objection, sir? Do you have an objection as to the photo itself? Huh?
It's not best evidence. It's improper to show that photograph of the witness.
Your Honor, I'm not sure what Mr. Shard is calling altered. The only thing that has changed is based upon previous objections.
Y'all want to come up? Excuse me.
I'm going to show what I'm now going to mark as 342 Yankee Oscar for original. Mr. Shard, do you want to come and see these? What is your objection?
Nikki, it don't affect his ability to practice law, but he just can't practice on this case no more. So pretty much he wouldn't be able to be on the case no more. But if you go back in the transcripts, I think it was day 50 or 60, something around there, Ms. Love injected herself into the case, and she was supposed to be thrown off the case. And the judge said that no, he didn't want to throw her off the case, and because that would stop his trial.
I'm now going to show you what's going to be 356 Yankee Oscar, 342 Yankee Oscar, 350 Yankee Oscar, and 351. Are those the same pictures that you just looked at? For the most part, you're shaking your head. You just got to say yes or no for the record for me.
Yeah.
Okay. Now, we were at 342 Yankee, right? No, we were at 350 Yankee. Besides yourself, just tell me everybody else you recognize in 350 Yankee.
You said show you what?
Besides yourself, tell me everyone else you recognize in 350 Yankee.
But you might name the people that's in the photo?
Yes, sir.
Me, Shannon, DB.
Do you know the fourth person?
I can't really tell his face.
Okay. Does that appear to be a fair, accurate depiction? So does that look like you, Shannon, and DB back in 2014? 2013, excuse me.
I'll sustain the objection. You can rephrase me.
Does that have a date on when this picture was posted to Instagram on there?
What you mean?
Does it have a date down here? Can you see that?
I can't see that.
Okay. But does that look like the three of you, DB and Shannon? Does it look like y'all?
I just said yeah.
Okay. Your Honor, this time the state would like to tender Stacey Exhibit 350 Yankee into evidence. 350 Yankee Oscar into evidence.
Any objections to states 350 Yankee Oscar? Hearing none, it's admitted, maybe published as you see fit.
Thank you. Now looking at 351 Yankee Oscar, do you recognize anybody in 351 Yankee Oscar?
Yeah, she got a real attitude. Their whole office like that. Set a bad example for women.
Do you recognize anybody in 351 Yankee Oscar?
Hit that like button,
Do you
yo.
recognize anybody in that picture?
Yeah, the same three.
Okay, so you, Shannon, DB?
Yeah.
All right. And does that look like the three of you back whenever you all took those pictures?
It's my first time seeing this picture.
Okay, but is that y'all in the picture? Yes. Your Honor, this time the state would like to tender 351.
Any objection to state 351? Yankee or Yankee Oscar?
Thank you, Your Honor. Yankee Oscar. We're going to not publish that version. We're going to get. We acknowledge what his objection is, and we have corrected it before we published it.
You want to show it to him?
If he can come over to Miss Knight.
She got a real nasty attitude. Their whole office got attitudes.
Just okay.
Sad. That's about to get bad.
Ryan State moves to tender Stacey Exhibit 351 Yankee Oscar.
Any further objection to states 351 Yankee Oscar? All right, it's admitted, maybe published as you see fit.
Next, Mr. Copeland, I want you to look at Stacey Exhibit 342 Yankee Oscar. Tell me if you recognize anybody in Stacey Exhibit 342 Yankee Oscar.
Wait, this one?
Yes, sir.
It's blurry.
Okay. Do you recognize anybody in that picture, although blurry?
I can tell this me, but I can't really tell who the other people are.
When you say it's blurry, can you see anybody else on there, or you can't recognize no one?
No, I could see, but I can't really see their face like that.
Okay. Looking at 356 Yankee Oscar. Do you recognize 356 Yankee Oscar?
It looked like me.
Is there anyone else in there that you recognize?
Yo, he said, look like me. It look like me.
Most definitely me. I can't really tell who they did with me though.
Is that Shannon Jackson? Or Shannon Stillwell?
Nah, they dude got a mustache.
Okay, so is this your testimony that that is not Shannon Jackson in this picture?
All I can say, I can recognize me, but I never seen that picture before, and I don't want to say that's him if it ain't him.
Okay. You are permission to publish 350 Yankee Oscar and 351 Yankee Oscar.
Yes, go ahead.
Now, first looking at 350 Yankee, are you able to tell us which one described by clothing? Where are you?
What you mean?
Which one of these individuals did you?
Which one on what?
Which point to you in that picture?
With the hat on.
Okay, there's 3 people with hats on. Which person are you with the hat on?
With the writing on my shirt.
Okay. What does the writing say?
DRC, third YRC.
What does DRC mean?
DRC.
What does it stand for something?
You asked me what it means. DRC.
Okay, does DRC stand for something?
Not to my knowledge.
Okay. It doesn't stand for the robbing crew.
I'm not a rob.
Hold on.
Okay, that's fine. I'm asking you what does it stand
Hold on. A sustained objection is to form. You can rephrase.
Okay. What does YRC stand for?
YRC?
Yes.
This stuff don't have no meaning. That's how I got this shirt.
Okay. That's your testimony today? That neither DRC or YRC mean anything?
That's how I got the shirt.
Okay. I understand that. I'm asking you, is this your testimony that DRC nor YRC mean anything?
I'll rule the objection.
Is that your testimony? That doesn't mean anything.
I said this how I got the shirt. So the shirt didn't have no meaning to it.
Okay. Who else do you recognize in that picture?
I just told you, me and DB.
Right. I saw it. The jury did not see it. So I need you.
My bad.
Okay. So which one is DB?
He died.
And I'm sorry to hear that. Can you tell me who he is in the picture, though?
What you mean?
Just tell the jury, what is he wearing in the picture?
I can't really see what he got on.
Is he the one in the green hat or the one in the purple or the one in the blue New York Yankees cap?
You said green?
Is he the one with the green,
Okay,
greenish hat?
I just didn't know the color.
Okay. So he's the one with the, like, behind you a little bit.
Standing behind me?
Yeah.
Yeah.
Okay. And then you said you recognize Shannon in this picture. Where's Shannon?
With the blue on.
With the blue hat on, the New York Yankees cap?
If that's what it is, I guess.
Okay. All right. Thank you. And are you able to see on there the date of that picture, or is that blurry for you?
No, I can't see.
Okay. Looking at that picture, can you tell me about how old you were in that picture?
You look like I was in elementary school.
All right. But is it fair to say that it wasn't within the last 3 to 5 years?
Huh?
Was it within the last 3 to 5 years?
I've been in jail.
Okay. So it's fair to say it was before that. I just need you to answer for the record.
See, the devil busy. I've been in jail for the last 3 to 5 years.
Okay. So it was before that. This is yes or no?
I don't even know which one to say yes or no to.
Okay.
If I say yes, I'm saying yes to it.
The picture was before 3 to 4 years ago.
The picture when I was younger.
Okay. Next, can we please publish State's Exhibit 351 Yankee Oscar? Now, I think before you said those were the same 3 people in 351 Yankee Oscar. Is that you on the left with your hands up and you have on the shorts?
I'm standing to DB right.
Okay. So that's to my left?
I think.
All right. And then is that DB in the middle?
DB in the middle.
And is that Shannon to the right? Or to my right?
It looked like Shannon.
Okay. And again, about how old were you when you took this picture?
I don't know.
But it's fair to say that you were younger than you are today.
Say that again?
It's fair to say you were younger than you are today.
Yeah.
Okay. Do you think it was around the same time you took the other picture that we just looked at?
I can't say when.
Okay. Thank you so much. Now, we spoke about your relationship with Shannon. As your friendship developed, did you all share personal information with each other?
What you consider personal information?
Did you talk to him about your secrets? Did you confide in him about life, things that had happened?
Now, my secret go to the grave with me.
Okay. Were you someone, did you consider him like a brother to you?
Still do.
You still do. Now, outside of you and Shannon, did you all have another friend that you spent a lot of time with?
Meaning?
Is there any other person that the two of you collectively spent time with?
It's all 3 of us together?
Yes.
A lot of time together? I don't know about it.
Okay, is there someone that you spent time together with Shannon?
I spent time with Shannon with a lot of people.
Okay. Let me ask you this. You just said that Shannon, you still consider him like a brother to you. Is your relationship the same today as it was, say, back in those pictures?
Say that again?
Is your relationship the same with Shannon today as it was back when we were looking at those pictures?
No.
How has your relationship changed?
It's better.
It's better now? Why do you say it's better?
What you mean?
You saying it's better?
I barely knew him.
Is your relationship with Shannon the same today as it was back in 2014?
I can recall 2014. I've been in jail so much.
Do you know someone by the name of Demekion Garlington?
Street name.
Little D.
For sure.
How do you know Little D?
I didn't birth him.
I'm sorry, say that again.
I almost birthed him.
You almost birthed him?
Yeah.
Tell the jury, what do you mean by that?
I mean, he my son.
Okay. And let me ask you this. Do you know another person who's referenced as Little D?
What you mean?
Do you know someone who's called Little D from Cleveland?
Oh, I heard of him.
You heard of him. Okay, we'll talk about him in a moment. Now, the Little D that you said is like your son, is that what you said? How did you all first meet?
What you mean?
How did y'all meet? You say you like your son.
I don't know how we meet.
You don't know how y'all met?
Nah, I don't recall how me and him first meet.
Okay. How long have you known him? And if you're 32 now, just
I knew him I knew him longer than Shannon.
Okay. Did y'all grow up in the same neighborhood?
Mm-hmm. Probably, but we never hung.
How old do you think you were when you started hanging with Lil D?
I don't know.
If we're in 2024 now, did you start hanging with him when you were elementary school?
Come on, lady. He said he don't know.
Or high school age?
I don't remember.
Don't remember.
I know when DB died, this when I took him in.
Do you remember what year DB died?
I don't remember when DB died.
Do you know what section of the city Demekion is from?
No, I do not.
Did you all ever attend school together?
No, I can't go to school with my son.
Okay. Well, when you say it's your son, how old is Demekion? If you 32, how old is he?
I don't know. I don't know.
Is he close to aging for you?
What you mean?
Is he close in age to you?
He's probably about 10 years younger than me. I don't know.
So you say Lil D is about 22 right now?
I don't know.
You said he's like your son. How often would you spend time with Lil D?
What you mean?
How often did you see Lil D? Back in, say, 2014, 2015?
I used to see him around.
Okay. How often?
I can't say.
You can't say? All right. Did you speak with him over the phone? Did you speak with him on the phone?
Speak who over the phone?
Lil D.
When?
At any time.
Yeah.
Since you've known him. How often would you speak with him on the phone?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
Whole time.
And I understand until you answer the question, I'm going to have to ask you again. So was that every day? Was that weekly? Was that monthly? What was it?
I don't know.
I'll go back. In a week, how often would you see him?
What you mean? When are you talking about?
Back in about 2013, 2014. 2013 to 2015.
Well, yeah, he stayed with me.
Okay. When did y'all live together?
He didn't really stay with me, but he stayed at my residence.
Okay. Were you staying at the residence at the same time?
But I was in jail, so.
Okay. So while you were in jail, he was living where you live. Prior to you going to jail, which you went to jail in 2015, is that fair?
I went to jail 2012, 2013, 2014, 2015, stayed in there 2019.
Okay. When you went to jail before 2015, were you in and out of jail?
When I went 20 what?
In 2012.
2012.
How long did you stay in jail?
I got out 2013.
Okay. Did you go back to jail in 2013?
I got at the end of the year. I went back 2014.
All right. And then between 2014, did you get out of jail in 2014? Is that a yes?
Yeah, I got out.
And then did you go back to jail in 2015?
2014. I went to jail like a couple times 2014.
Okay. So you were in and out.
Right.
And then in 2015, did you go back into jail?
Yeah.
And is that where you spent the long duration?
I went to jail a couple times in 2015. But the last time I stayed until 2019.
Okay. And it was the last time that you went to jail in 2015, June of 2015.
That was the last time, yeah.
Okay. And so prior to June of 2015, you were in and out that year between January and June.
Right.
Okay. In the periods that you were not in jail, did you and Lil D ever live with each other when you were not in jail?
In 2015?
We'll start in 2015, yes.
Nah, he ain't stayed with me in 2015.
Okay. In 2014, those times that you were not in jail, the Lil D stayed
right.
with you. And then what about 2013? The times that you were not in jail, did you and Lil D reside with each other?
What you mean?
Did y'all stay with each other and did he stay at your home at any time in 2013 when you were not in jail?
2013 when I started to get to know him.
Now, you said that he's kind of like your son. Did you all share things with each other? I'm talking about conversations, personal conversations between you and him and vice versa.
Not no secrets.
Okay. But did you feel comfortable speaking to him? You did not?
Nah.
Okay.
I didn't feel, I don't know what you mean. Like, I didn't not feel comfortable. I didn't feel like certain stuff we just don't talk about.
That's fair. Did you consider little D like a brother? I know you call him your son, but did you consider him like a brother?
I consider him my son.
Okay. Do you recall ever telling any detectives previously that he's like a brother to you?
I probably did. Ain't no telling.
Okay. Y'all permission to approach?
Have you shown that to the defense counsels already?
Yes. Well, no.
Just make sure you show it to them.
I will. Permission to approach, Your Honor?
You may, madam.
I'm showing you what's marked as State's Exhibit 358 Yankee and 380 Yankee. Starting with 358 Yankee, do you recognize anyone in State's Exhibit 358 Yankee?
Yeah, me and my son.
Okay. Is that the person that you've been referencing as Little D?
Yeah.
All right. And looking at 380 Yankee, do you recognize the individuals in State's Exhibit 380 Yankee?
You said what now?
Tell me who you recognize in 380 Yankee.
Me and Coco.
Who's Coco?
The ugly boy right here.
Okay. Do you see the person that you said is your son, Little D, in that picture?
The restaurant got the head down.
Okay. Your Honor, this time the state would like to tender State's Exhibit 380 Yankee and 358 Yankee into evidence.
You said 380 Yankee?
Yes, Your Honor.
And what else?
358 Yankee.
Any objection to states 380 Yankee or 358 Yankee?
Yes, Your Honor. Lack of foundation for 380 as well as hearsay included on 380.
What about 358? All right, 358 is admitted. Let me see 380, please.
And I can lay a little bit more foundation for 380 Yankee.
All right.
As far as the hearsay.
Okay, then go ahead.
Mr. Copeland, have you previously had an Instagram account?
Say that again?
Have you had an Instagram account?
Yeah.
And how many Instagram accounts have you had?
I don't know.
Okay. How many different names of Instagrams have you had?
2.
2. Okay. Has one of your accounts been 372 Woody?
I can't recall.
You can't recall. Okay. Are you Woody. That's what they call you, right?
For sure.
All right. And do you know any other Woody who hangs with you? Is there anybody else in your friend group that they call Woody?
Yeah.
Oh, how many other Woodies are there?
Jamie and the other one.
Okay. What's the other one's real name?
He died too. I don't know his real name. I think it's damn. I know his last name Bridges.
Looking at that picture, is the other Woody in that picture?
I can't tell because the other guys got their head down.
Okay, well, just look and see if you see someone who looked like the other Woody, even with their heads down.
Can you show me a clear picture?
When you say clear, what's not clear?
Because he got his head down, he got his head down. My hand covering his face.
Let me ask you this, when did the other Woody pass away?
Right before I got the feds.
When you say right before, meaning that year, a few months, what do you mean?
I got it like September, and somebody killed him, like probably, I don't know when, but they killed him before I got out.
Before you got out, okay. All right. Looking at State's Exhibit 380 Yankee, and looking at that picture with the 372 Woody, is that from your Instagram?
You talking about the one with all these people in it?
Yes, sir.
Okay.
Is that from your Instagram?
I don't recall this Instagram. My Instagram is Woody versus Woody.
Is that your newest one?
What you mean?
Is that the one that you currently have right now?
No, the one I currently have now is Woody_self-made.
Okay. So are you saying you don't know if that's your Instagram?
I don't recall this Instagram.
You don't recall that Instagram? Okay. You're right.
If it's mine or not, I don't know nothing about it.
But do you see yourself in this picture?
Which picture?
The picture that's posted on this.
Yeah, I'm sitting right there, ain't it?
All right. And right here, you can't tell if you see the other Woody.
I can't. I can see me and him real clear. Both of us got our heads up.
All right. Your Honor, again, state will still like the tender State's Exhibit 380 Yankee.
Let me see it, please. All right, any further objection to 380 Yankee, sir? We all approach, please.
published once it's submitted with the court's ruling. First, we're going to publish 358 Yankee. And looking at 358 Yankee, can you tell the jury, tell the jury which of the two of you is little d or who you call your son? Which one? The person to the left of you, right of you?
What you mean?
Is that little d to my right?
This little D in the picture with me.
Okay. And do you know about how long ago you took this picture?
No, I don't.
And we keep saying little d or your son. Do you know his given name? His real name?
No.
Do you know his real first name?
You said Demikian Garlington.
Okay. And is that the person that you know is little d?
This little D right here in the picture with me.
And is that Demikian Garlington?
This little D right here.
Is that Demikian Garlington?
If this was his name, then yes.
Okay. Now showing you 380 Yankee. Can you zoom in to the picture? Now, looking at 380 Yankee, is as you sitting on the step in a white t-shirt and blue jeans and black and gray sneakers.
Yes.
Okay. And who's the other person you said that you knew in this picture?
The ugly boy right here.
Okay. And what is that? What is the individual that you pointed to? What's their name?
Coco.
All right. And in this picture, the person behind you with the 30 deep B. I think it's BITXH shirt on. Do you know who that is?
I can't recall who that is.
You cannot recall. Does that look like Demikian or Little D? Does that look like Little D?
The head cut off.
Okay. If you could, can you turn your chair around and look behind you?
What about it?
Does that look like Little D?
I guess.
Okay. Well, is someone you call your son? Does it look like the person you know to be your
I can't see
son?
that far. I just told you that from the beginning.
Okay. All right. What, if anything, are you doing with your hands in this picture?
I'm doing nothing with my hand.
Okay. I want to go back to 358 Yankee. What, if anything, are you doing with your hands in 358 Yankee?
What you mean?
What, if anything, does what you're doing with your hands symbolize, if anything?
A bird.
Okay. Does it mean anything specific?
No, throwing up a bird.
Why are you throwing up a bird in this picture?
Because I'm from Mechanicsville.
Is that the symbol for Mechanicsville?
We represent a bird.
Okay. And then what about Demikian? Are you familiar with the hand gesture that he's using?
Say that again.
Are you familiar with the hand gesture that Demikian is using? And no,
I don't know what that for to mean.
you don't. Okay. How is your relationship with Little D today?
Meaning?
Do y'all still have the same relationship that you had back in, say, 2015?
No, we don't.
Okay. How has it changed?
I wanted him to lie for me, and he wouldn't.
Okay. And when was that?
back in the day.
When you say back in the day, what do you mean?
When the police was accusing me for stuff, I went to Lil D and told him what I wanted him to tell the police, and he went to tell the police that, so I got mad at him.
Okay. And what year are we talking about that this occurred?
I don't know.
Are you speaking about one specific occasion or just multiple times?
No, I'm talking about one specific occasion, however you pronounce it.
And is your testimony that you have not been friends with him since that time?
Now, I have spoken with him, but our friendship ain't been the same.
When you think about your friendship with Demikian and your friendship with Shannon, at this point, who are you closer to, Shannon or Demikian?
Myself.
Okay. But outside of those, I'm speaking specifically about those two individuals. Between Shannon and Demikian, at this point, who, if either of them, are you closer to?
I don't understand what you're trying to say.
You and Demikian, that's like your son, right?
Right.
And you said that the two of you, I'm just trying to clarify for Mr. Copeland. You consider Demikian like a son. Is that fair? Who are you closer to today? Demikian, Shannon, or neither one of them?
God.
Okay. That's good that you're close to God, but I'm talking about Demikian, Shannon. Who are you closer to today? Demikian, Shannon, or none of them, or neither of them?
I guess neither. I don't know how to answer that.
Back in 2013, 2014, 2015, that's the time frame we're talking about. How close was the relationship between you, Shannon, and Little D?
It was difficult.
You said it was difficult?
Right.
How was it difficult?
You just put 3 years together, so a lot happened within 3 years.
So let's first start with 2013. Describe for the jury your relationship with Demikian, Shannon, and Little D. Let's start with 2013. Tell the jury about your friendship and relationship with those two young men back
then. As in what?
Were you three of you close? Were you not close? Tell the jury about your friendship.
Look, I took special ed classes. You got to talk to me in a way that I can understand.
Sure. Back in 2013, were you friends with both Little D and Shannon?
Yes.
Okay. How close were the three of you back in 2013?
Again, my friend was killed. That's when I started embracing Little D.
All right.
In 2013.
When you started embracing Little D, were you and Shannon friends at that time?
Me and Shannon was friends, but me and Shannon was not together on the street as much as friends. We was not together a lot.
Okay. When did you, Little D, and Shannon start hanging together a lot?
20.
Did you, Shannon, and Little D hang out together?
Yes.
When did the three of you start hanging around each other?
The longest I've been out of jail was 2014.
To your knowledge, did Little D and Shannon, strike that. How did the three of you all start hanging out together?
I don't know.
Did you introduce Little D to Shannon?
No.
Did you introduce Shannon to Little D?
No.
Okay. Did Little D and Shannon know each other before they knew you? Do you know if they knew each other before they knew you?
I don't know. I don't recall how it started. I just know I started embracing DB, Lil D, after DB got killed. Lil D was more a DB friend.
After DB passed, you embraced Little D. Did the two of you start hanging out with Shannon after that?
I just said, how could I say this? Me and Shannon wasn't together in so long to be on the street. So I don't know when our three of us was able to get together. I just know at one point we used to go to the club together.
Did y'all do anything else besides go to the club together?
Yeah.
What? You said that you all would hang out. Did you all spend time at each other's homes?
No.
Okay. Did you all spend the time at other people's houses together?
What you mean?
Like, did you all go to other people's houses and spend time at other people's houses together?
We didn't spend time at people's houses, but we don't been, we go to people's houses.
Okay. You said you went to the club. Would you all go out to eat together?
Yeah.
Okay. Did the three of you go on any vacations together?
No, we don't do vacations.
Okay. Did y'all ever take any trips out of town together?
Not that I recall.
Were you familiar with any of Demikion's family? His mom, his
I know his mom.
What about Shannon? Did you know his grandmother or any of his other family members?
No, I didn't.
You have children. Did they have any type of relationship with your children, Little D or Shannon?
No.
Okay.
Not that I know of.
All right. What about you? Did you ever spend time? Let me back up. Did Little D have children?
Ain't no telling.
Okay. To your knowledge, does Little D have children?
Not to my knowledge.
All right. To your knowledge, does Shannon have children?
I think so.
Okay. Have you spent time?
Well, Shannon have children.
Yeah. Have you spent time with his children?
I have.
Okay. Have you taken them to birthday parties?
But my relationship with his children is not through him.
Okay. Who's it through? Their mother?
Yeah.
Okay. No permission to approach. Show it to him now, Your Honor.
I'm gonna pause that right here. Some paperwork just dropped. Hold on. Because as I pause that, hold on. I gotta get this paperwork. Hold that thought. Some paperwork just dropped. Hold on. Let me grab it. Okay, the paperwork that dropped was this right here. The paperwork that dropped is in the Superior Court of Fulton County. It was filed at 4/24 today. State of Georgia versus Jeffrey Williams, defendant Brian Steele Movant. Indictment number 22 SC 183572, Judge Glanville. Notice of appeal. Notice is hereby giving that Brian Steele hereby appeals to the Court of Appeals of Georgia from the order of contempt on June the 10th, 2024. Brian Steele. It says Brian Steele in criminal contempt. The clerk will kindly take note that the transcript of evidence of the proceedings on June the 10th, 2024 are to be included with the record on appeal. No other portion of the record is to be included for this appeal. The Court of Appeals of Georgia has jurisdiction of this case on appeal. This 10th day of June 2024, respectfully submitted Colette Resnick Steele, his wife. Okay, Judge Glanville just got himself in some hot water. But yeah, let's continue this thing. Okay. Judge Glanville just got himself into some hot water, so okay. Lord have mercy. And the bad part about it is, from what I'm seeing right now, all of Trump's lawyers are fighting behind Brian Steele. They are all coming to help Steele, which you know what that means. Shout out to Ashley Merchant. Shout out to Ashley Merchant. And shout out to Attorney Adams.
Now that it's bigger, able to identify the individuals that's in 345.
And what you asking me?
Tell me who you recognize in 345.
Nobody.
So you don't see yourself in here?
Trying this in this picture?
This picture right here.
This photo me?
Does it look like you?
I ain't never seen this picture before, so.
Not that I've seen it before. Does it look like you?
Yeah.
Okay. Do you see anybody else that you recognize?
I think they Lil D.
Okay. Does it look like Little D?
Mm-hmm.
Is that a yes for the record? All right. Do you see anyone who looks like Shannon?
No.
No.
They look Rick.
That's Lil Rick. Okay. Is there anyone else that you may recognize in that picture?
Done.
Okay. Anyone else?
That's it.
You say Don or Dot? For the record.
Who?
The person that said, what's the name you just said?
Done.
Dot?
Yeah.
D-U-N-T?
Yeah.
You're on this side of the state, like the attendance states is 345.
Any suggestions, days 3:45 game?
Yes, Your Honor. I believe it's photos at this point.
That's the
And I have a response to Kim.
come on, sure.
I want everybody to pay attention because something happened with this, and again, I'm gonna find it and I'm gonna show it to you. This is crazy. Pay attention to the body language of everybody. This delayed. I delayed this one. I took it back some.
All right, let's take 10 minutes and then we'll see where we are then. See where the day leads us. All rise.
I got a headache.
We'll be in recess 10 minutes.
I might take the fifth.
Oh, hold on. Hold on. Wait 1 minute. Hold on. Hold on 1 minute. Hold on 1 minute. Did y'all just hear what just happened?
We'll be in recess 10 minutes.
I might take the fifth.
Hold on. Going off of that recess, right? Going off of that recess. Are you looking at the judge body language? No, Tiffany, you don't understand what's going on. Hold on. She's trying to get him to lie. And he said, I'm about to take the fifth. Pay attention to Glanville's face. That wasn't the first time he said it. That's why Glanville was looking like, what the hell? Pay attention.
Yeah. All right, let's take 10 minutes and then we'll see where we are. See where the day leads us. All right?
I got a headache.
They cut. Watch Glanville face. He said something right there.
I might take the fifth.
So, hey, Chi-Town. So whatever he said got them spooked. Because now we into real time now. And this is more than 10 minutes. We're in real time now. And this is way more than 10 minutes. So just giving y'all a heads up that Brian Steele's wife has filed. I just read Brian Steele's wife has filed for him to be out, and right now they on recess. So while they on recess, I'm gonna take this time to show some things, and I'm definitely gonna be keeping up with this and seeing. I wasn't even going to do this trial because of my closeness to the trial. But I can't get in the courtroom because, you know, he's not going to allow nobody else to file a Rule 22 right now and to get in. So, you know, that counsels me out. But while that's going on, I'm gonna show something concerning. I'm gonna show something concerning. I guess you want to say. You want to say a case or something like that. Like, So I'm gonna show my situation real quick, which involves me a lot of along with the government. So I'm gonna just cover this real quick, and I'm gonna break this down just for you real quick, okay? I'm gonna break it down real quick. We're gonna do it like this. It says, what is this? Nope, that's not it. That's not it. Nope, that's not it right here. Sent me the wrong thing. Okay, here it is. It says, okay. It's a clerk's notice, reason consent. A United States magistrate judge has been assigned to this case and is available to conduct all proceedings in accordance with Rule 73 of the Federal Rules Conduct of Procedure, Local Rule 73.1. The parties are notified. The parties are notified that if all participants consent, and I want y'all to see, it says all parties are notified that if the participants consent and the assigned magistrate judge is available to conduct proceedings in this action, including a jury or non-jury trial, and order the entry of a final judgment. Attached to this notice is a copy of consent form that should be filled out, signed, and filed electronically. Only keyword, only if all parties wish to consent. Any party may withhold its consent without adverse substantive consequence to not return or file the consent unless all parties have signed the consent. The form may also be accessed at the following link. Clerk's notice, consent, a United States magistrate judge has been assigned. Okay, the same thing right there. Blah, 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 blah. So this boy motion for leave to proceed in form of paupers by Christopher Gunn. Okay. It's a complaint against Mercedes Aquino and Maria Cruz and Maria Cruz Alendez, Esther Garcia, Elizabeth Geddes, daintezjackson, Gregory Levi Stubbs, Talia Martin, Larry McGee, Olotokombo, Olayan, Nada Shahada, the Oak Cove, Sun Times, or whatever that is. Then they got the Oak Cove again, filed by Christopher Gunn. Okay. One thing for sure, two things for certain, right? The judge is Natasha C. Murrell, referred by Peggy Cool. Let me break this down real quick. First of all, we're going to rock like this. This is a lawsuit against us. And I guess because he got locked up for him threatening the AUSAs, right? So watch this. The minute you grouped all of us together, and me, Larry Levi, Ty, Oak Cove, none of us talk. None of us. But do you realize that grouping us together is dangerous as hell? And the reason why I say that is not in a sense where we gonna do some harm to you. That's not the danger part. And the danger part is you got everybody that thinks grouped together, and we have everything that you done to us separately and collectively. So now, here's the problem. You filed it wrong. And I'm not going to tell you how to file it right, because what I now notice is that since y'all been reading my paperwork, and because I file all of my paperwork under indignages, y'all the ones that's trying to steal how I file my paperwork. After coming on the internet and trying to downgrade me and talk about me for filing my paperwork like that. Because you filed for a motion to leave and to proceed in forma pauperis, which means indignages, which means you can't pay for the charges, right? But guess what? Here's where you about to fuck up. You are a U.S. citizen, ain't you? If you're a U.S. citizen, you can't proceed in forma pauperis. If you're, see, this shit gets so deep. They hate me so much, but they try to copy everything I do. So now I'm going to contact the courts. And now I want to know why U.S. citizens are filing to proceed in forma pauperis when they rich. There's videos with Dubowski, Christopher Gunn. I got this money. I got this money. I got this money.
All right.
Oh, hold on, because it came back. Hold on. I'm going to pause it so that way y'all don't miss nothing. But I got to continue this real quick. So proceeding in forma pauperis, right? The bad part about that is y'all rich. Y'all got all the money. So I'm going to submit those videos as well. Because y'all rich. Y'all got all the money. Secondly, you can't file the same lawsuit in two jurisdictions. And you filed it in New York and Chicago. That means it's a conflict of interest between courts. Nobody have jurisdiction. Third thing is this right here. That's all we got to say is no. We ain't dealing with it. Because you didn't file it right. So I'm going to say this. And we're going to do a one-time thing only. Right? A one-time thing only. Because now y'all done pissed me off. And you want to go this route. So now I'm going to go this route. You grouped us together. You grouped Larry, me, Levi, Okove, Ty, a Mercedes. You grouped all of us together, right? All right. Sometimes you need to leave well enough alone. Be prepared what you ask for. That's all I'm going to tell you. Be prepared what you ask for. I'm going on record and I'm saying I'm not dealing with this. I'm not dealing with this. And what I'm going to do, I'm going to write my rebuttal to both courts. If we're going to go that route, I want to countersue. And my countersuit is involving T-Baby and Sarah Remy and your mama. Let's go. Back to the Young Thug court we go.
jury.
All right, ladies and gentlemen, please be seated. All right, ladies and gentlemen, the jury, how you doing? All right, listen, it's, as you can see now, the hour is almost 6 o'clock, and, you know, there's some things we had to take up, so we're going to recess for the evening, okay? So tomorrow morning, 9:30 for an anticipated 10 o'clock start time. All right, any ministerial inquiry of me? Okay. All right, ladies and gentlemen, let's go through your customary nightly admonitions, okay? Remember, as you leave here today, remember to leave your notepads in the basket. Do not discuss this case in ones and twos or back there as you are in your in your headquarters at your deliberation room, or as you're going back and forth to your homes of residence in our great county. Also resist temptation as well to even as in ones and twos for you to discuss the matter. Remember, I told you that it would be a violation for you to recap or otherwise handicap the testimony as you sit back there, because remember, you can only consider this case properly and lawfully, bless you, at a time and place and space that the court kind of tells you you're able to authorize you to do that. Remember, you cannot seek the advice of any third parties, any third party websites, any research or reference materials, any other things that would allow any extra information, okay? Remember as well that if anybody should talk with you about this case in your presence or hearing, you need to, of course, let myself and Sergeant Ingram know immediately. And remember, you cannot go by any scenes that may be depicted or may have been talked about during this case at all. And remember, you can't take any pictures, discussions, or anything such as that. You're supposed to consider only what's been presented in this courtroom. All right, ladies and gentlemen, as well, thank you for your patience. Thank you for the attention that you've given this matter, and the attention and patience you'll continue to give this matter. And unless you have any other ministerial inquiry of me, I'm going to release you till tomorrow morning at 9:30 for an anticipated 10 o'clock start time, okay? All right. All rise for our jury.
Wow. Wow. Right, Prima. Hold on, but I'm going to talk about it in a few minutes. Hold on.
All right, Mr. Copeland. Sir, over here. Over here.
Yeah, Nikki, I did.
The state has filed an order or request asking that you be relieved of your custodial portion of this particular contempt on the condition that you just continue to come back and give your testimony, okay? So I will release you from the custodial portion as long as you come back tomorrow morning. Fair enough? If you're not willing to do that, I'm going to leave you where you are. So the choice is yours, sir. The state's asked me to sign the order saying, hey, if you'll come back tomorrow morning, all I want to know is if that's the case.
I'll be back.
All right. 9:30 tomorrow morning, okay?
All right.
All right.
But that's all they got to do is come back and plead the fifth. That's it. I plead the fifth.
Copeland, be released and processed. Say again? Yes.
I'm weak, man. Y'all can speak to me when I get out.
What?
Right.
That order, I'll go ahead and sign it, and I'll also make a copy of it as the next court's exhibit in order, and we'll e-file it this evening, okay? All right. Okay, Mr. Steele, are you willing to tell me at this point in time who it is that disclosed this information to you?
Unbeknownst to me, Gactyl is here, but they're not being allowed into your courtroom. I presume they're outside. So I'll wait on them to come in.
I'm asking you, sir, because the contempt is for you. It's not to the Georgia Association of Criminal Defense Lawyers.
I didn't call them, but
Okay, and that's.
Let me just finish.
Okay.
You said to me that you figured out somebody told me this information, and you somehow said that it's privilege, which I can't imagine, or I eavesdropped. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. But they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just.
Or they're not in your courtroom.
We just don't have any. We just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that we'll fill up our benches at this point in time, that won't violate our security protocols, but that 8H is available. And
8H then has to have right to counsel because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Ashley Merchant is here. She's the president.
Okay,
Yes!
all right, we'll let Ms. Merchant in.
Yes!
Ashley Merchant.
Yeah, Ashley Merchant. All right.
Let's go, Ashley.
Ms. Merchant, good to see you as usual. I have told your client, you represent Mr. Steele, is that correct? Yes. For the purposes of the contempt. I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedious bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt Only thing I want is because of the way this information was disclosed, it is troubling to the court and is very, since it was a ex parte communication, we won't get into the merits.
No, it's not troubling to the court.
Mr. Steele
Y'all got caught in y'all scheme.
Else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
No.
Judge, can you come up to the microphone?
Please. Microphone, it'll pick up, madam.
Let's go, Ashley.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is the criminal contempt, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Okay. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So
it's not a alleged conversation.
It is a criminal contempt. He is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
okay. Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms. Merchant.
It is in re McClarty. It's 152 Georgia App 399.
Got him!
And it says that is one of the cases. Also, two other cases. In re Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. In re what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
I might get kicked out of Fulton County Courthouse
Georgia
now,
App,
but I don't care.
372.
Okay.
Also 215 Georgia App.
Oh, she mad.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those.
See, the devil won't act stupid.
Current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. But I do have other.
You playing with the dog now. This what you didn't want. You playing with the pit bull now. Here we go.
And Judge, I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I have space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H, and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
They still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom, so we would ask that they be allowed to.
I don't want them in my jury box, okay?
Wow.
No.
I understand.
He is exposing himself. So now he going against case law. Jesus. And then he said he don't want them in his court.
One additional attorney come in, then Alex Souser. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, I certainly may, sure.
Great. Alex Susor. Alex Susor. Thank you, Judge.
Henry Adams, it has two issues. One is the motion for disqualification. Okay. And that's
Oh, Alex. Oh, this about to get ugly.
and I think the judge went ahead and did some other things that caused there to be that issue presented. So
That's what I said, Nikki.
I don't think Adam, I'm gonna take a look at the other case. That was Henry Adams. That was 215 Georgia 372.
Yes.
The other case.
And there's several others when you're ready.
She about to run them all down. I knew this was, oh boy, I told you. He tongue-tied now. He don't know what to say. He faking like he reading, but he know he's tied up some kind of way. Man.
Yes. It may be one I have too.
He said, when you see a ponytail that's cleaner right there. Look, they don't know what to say. Like, dog, like, what I get myself into? Man, get him off the snap. Listen, Glanville need to go. Don't cut the feed. We don't want the feed cut. Hold on, let's go.
Is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people, and as to how that information was disclosed. That's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm going to disagree with you, okay?
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum in the court is exempt from due process requirements notice and hearing. That's even moody. It goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him just to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but the representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them, by nature.
Okay. Well.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also
But you got the information. But here's the thing. You got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that.
Yes, you did. You did say that.
It's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that.
Oh, now your story changing.
But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me? Yes, Judge. There's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways. I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record in this case. He's filed a motion to set aside the contempt. He's filed a motion for a supersedious bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a supersedious bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
just the case law on that is in Ray Hughes.
Hold on.
Wow. Jesus Christ. Glanville. Oh my God. Jesus Christ. It's always us. All skin folk ain't kinfolk.
The superseded bond requirement does not apply in a contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt, respectfully.
But it's not a criminal contempt, it's a direct contempt.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
Judge, and that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that
don't cut him off.
I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Well, Judge, I think I'm addressing it
right, Bremer.
Point of
it
law.
is. Hold on.
Jesus Christ. This case is over with.
I'll give you two cases. One is
Judge Glanville done said 4 times that he's going to be found guilty.
And TEMA versus Smith, and that's 371 Georgia Appeals 19.
Ashley going to destroy this case. Watch.
March the 12th of this year. It covers the differences between the types of contempt. And then there's another case that I'd invite your attention to, and that is Henry Syverson. It's SYVERTSON, and that is 368 Georgia Appeals, Georgia App, I should say, 865. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other...
I'm not going to grant a supersedious.
And so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and a $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he, when he tells me what
you can't do that.
The conversation was.
You can't do that.
I didn't ask what, but he tells me that. Then
you can't do that. Can't do that.
He purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
Judge, and that's the. Respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and a $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge. which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who, the person, okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm going to take 5 minutes out and I'm going to think about it.
Thank you.
Okay, all right. So we'll be in recess about 5 minutes.
Oh my God, Lord have mercy. This is crazy. This is crazy. Judge Glanville has exposed all of his hands. So if you're going to hold him in contempt, why not hold him in contempt? Hey, Grandmother Jenna, why not just hold him in contempt? He didn't know what contempt he wanted to hold him in. This is crazy. And I told you, if Steele would have told who it was, Judge Glanville would have went 8 nuts on that person. Oh boy, this is wild. This is wild. But hold on. So my question is, what do y'all think? What do y'all think? Because I keep telling you, if you appeal or if you do not consent to what they saying, they don't have no power. And you seen it right there firsthand. And every time I said it, they called me what? You're a conspiracy theorist. You're going to jail. No, they need your consent to do everything. And if you don't give them your consent, yeah, they can try to do something, or that. But then when they come back around, they going to get in trouble, or the barred, and you going to be whatever you want. That's why I say now, there's no way this case can go forward. If it do, Judge Glanville today has said 4 times that Young Thug and his constituents are going to be found guilty. Because that's all he keeps saying. Well, when it go to the appellate court, hold on. Why do it need to go to the appellate court if y'all still trying to find out information. And then he'll come back and say, well, I don't have enough information on this and this and this. But then here's the flip side. You hold a secret meeting with a sworn in witness, the DA, the DA's office, and a judge. The problem is, ain't none of the defense privileged to none of this. Then when the defense come out and say it, you shook like, oh, how you know that? Then you get cocky and get on the stand and say, y'all didn't have privilege to none of this. But what Judge Glanville didn't understand is he thought he was going to be able to do Mr. Steele any kind of way. But if you pay attention, when Mr. Steele said, my lawyer name is Ashley Merchant, he did like this. And then when Ashley came in, I said it's over, because if Ashley's there, it's about 400 other lawyers there. That's how they roll. And Love is one of the same people that Ashley destroyed in federal court. Then Ashley comes down and fight for Trump on the 5th floor. So now they call Ashley to come in, and then she go get some of her constituents as well. This is not looking good. At the end of the day, when you got lawyers that know how to fight, it's ugly. And the bad part about it is that everybody's getting out of Fulton County. Everybody's leaving Fulton County. And that's bad, because Fulton County is the biggest county in Georgia, and it's one of the beautifulest counties in Georgia. One thing I learned about the court, your ego can be dangerous. Having an ego could be dangerous. Now, my question is this. What do he have against Young Thug? I've heard some people say that he had some trauma in his life as far as people getting killed and all that. We all have. But at the end of the day, you got to realize Bryant Steele lineage. His wife is one of the hottest lawyers in Georgia. He's friends. His wife and him are friends with Ashley Merchant. Let's go deeper. They're friends with Donald Trump. Let's go deeper. Let's go to the black side. They friends with Al Sharpton. So I just don't get it. Like, Judge Glanville, you done dug a hole for yourself. And you making us look bad. Like I mentioned to someone today, Fannie Willis got to go. Because this is Fannie Willis' arm right here. She got to go. Time to cut the arm off. She got to go. And I'm not saying it because I don't like Fannie. No, because I'm going to be real with you. Outside of court, she cool. But inside of court, she a whole nother person. And what she do and the way she practices is wrong. Now, she bringing charges against people for retaliation. And remember, I told y'all this before. Listen, if this case was strictly about purging the community of drugs and gangs and all this, then it's nothing nobody can say, right? There's nothing nobody can say. But if you know the truth, she was dating Nut. When she went and said, I'm used to holding stacks of money, that was the money that Nut would give her to hold for him. And I was mad that nobody capitalized on that in her trial. However, this is get back for Nut because they believe that Young Thug had something to do with Nut being killed. Watch this. If you think I'm lying, go look back to like a couple weeks, within a couple weeks. If this was about strictly gang and drugs and purging them off the streets, why would you bring Peanut father in to testify about his son? Nobody knew about Peanut until this case went public. When I mentioned Peanut and I did that little clip on Peanut, folks was like, who is Peanut? What do Peanut got to do with this case? Now y'all seeing what it got to do with it. That was Fannie X Boo thing. So make this make sense. While Fannie was in Emory College or Emory University getting her law stuff, she was on the streets. There's nothing wrong with that. You can hang with who you want to hang with. And you can love who you want to love. And you can ride for who you want to ride with. But let's keep it a buck. She is using that office as a miscarriage of justice. Just like when she wanted to bring Harrison Floyd in. Well, if you're going to bring Harrison in, why you ain't bringing Garrison in? And everybody like, who's Garrison? Wait a minute. I'm going to go back and I'm going to show y'all the video again. You bring in certain people and you leave certain people out, and because of your connections with a certain people. You and Brian Kemp are cool. So why didn't you charge Brian Kemp's spokesperson? Because that would have destroyed your chances even more of you being reelected. Make it make sense. Brian Kemp would have threw that ultimate monkey wrench in your joint. And you don't want people to investigate in the 2020 election. And I said this once more, is that election is not just about Donald Trump and a Joe Biden. Fonnie Willis was on Joe Biden's ticket. So that means what? Her votes need to be investigated because a lot of her votes were false votes. So what they do, they drag it out and then they have another election and then they go get somebody that they know Fannie Willis is going to destroy. And nobody knew that man that she just ran against. But Courtney Kramer is another story. That's why I say what I say. That's why I say what I say. That part, busy mom, it be your own people that will destroy you. And my thing is this. If you're against gang and drugs and all this, why were you holding drug money from Peanut? Why weren't you trying to prosecute Peanut or trying to get him prosecuted back then? That part. That still brought the real YSL to Cora. I'm trying to tell you. Nap, man, listen, Ashley Merchant ain't playing with nobody. Nah, I just got a text message. They got 45 other lawyers out there, but they 45 deep. They 45 deep out there. Hold on, let me see something. Hold on. I'm about to find out right now. It's past 5 minutes. It's past 5 minutes. Hold on, wait a minute. Hold on. That's a good question. If the judge and state really intimidated and coerced Woody, which I believe to be true, they'll try to get those transcripts changed. Facts. Whoever KC is in a group, you know what? I'm about to say this. This is crazy. Hold on. File shifting. Well, let me see what y'all saying. Let me move this over. Let me look at, I'm gonna post y'all questions. Hold on. Busy Mom said the judge out of there. Judge out of there. Like, it's too much. It be your own people. Yep. Wow, just wow. Yep. Hold on. I believe that judge is on the phone with a higher power trying to discussing how to weasel out of it. I bet you. Someone just said Steele brought the real YSL in the courtroom. He got 45. He got 45 deep. He 45. Judge is calling his prayer warriors. Well, yeah, you shut up. You shut up. Soros paid them judges and DAs in the blue states and cities are corrupted. Facts. Like, you good? I don't care. He going to come back and say civil. They don't want to relinquish any power that will help expose all of their underhanded bullshit, right? File shifting. Judah, what you know about file shifting, bro? I believe it's going to be a mistrial. Let's get them likes up, y'all. I appreciate everybody. I got 85 in here. Let's get them likes up. Can I get 43 likes? This the real situation, number 9. Lex, what you know about that? What you know about that, Lex? Actually, his bar card. Oh, I keep forgetting that's their joint. Yeah, his bar card might be at stake right now. And somebody said Steele more solid than a Woody. Judge confirmed it when he said we already spoke earlier at that point. Right. He and the DA were trying to intimidate the witness into testifying. Right. Just release the transcript like you are legally obligated to do. Judge, unless you are hiding the fact that the witness was tampered with. There you go. I'm so ready to leave Georgia, man. I've been here 14 years. Matter of fact, I served my time here. I'm ready to go back home. She told the judge, sit your $20 A down before I make change. Yo, this chat is brutal. Hold on, look at this. I'm gonna put this on there. This chat is brutal. Hold on, look at this. This chat is brutal. The judge need to go, yep. I dealt with courts for years. They either would take something important out your life or make up a fake statement. Facts. That's facts. This chat is brutal, man. Hold on. Intimidation and coercion by this judge and prosecutor is highly illegal and unethical. They need to be protesting about this. They willfully broke the law and are now threatening defense attorney. Yep. From the start, hold on. They did not need an ex parte hearing to inform him they will release him if he just doesn't take this fifth. Wow. They sold his tail to the defense. Law scholars. These two state lawyers aren't lawyers. They are garbage, and I'll be applying elsewhere. Huh? Woody watching it from both sides. Who is feared the most? Let's see. Judge using excuse that he have to vet search those attorneys who are officers of the court was wild and lame. And then I don't want them in my jury box. Yeah, okay. We see you, urinal. Yo, this is crazy. Ain't no place like home. Angela, who you telling? I'm so ready to go back home. Everything is falling in line back home like I needed to. I'm about to get out of Georgia because I see what's coming. Euro back there talking to his lawyer. Why they call that man Euro? Who is Euro? Do anybody know who Euro is? You see the Wi-Fi stealing always in the car person in the chat. Your ex-mod. Nah, Nikki, I don't see him. I don't see him. You know, I ain't even looking for that dude. Somebody said the judge is in trouble. Thug was trying to tell them to stop committing crimes, but he not rich enough to feed everyone. Why would Euro think okay to meet without all lawyers? That just sounds suspect, shady. Yeah. Oh, I can't see him. Oh, I can't see him at all. But I mean, but why would he be in the chat that I told you, but them niggas love to follow the leader. They love to follow the leader. And like I keep telling everybody, if you pay attention long enough, you'll see that they all try to follow me. Nah, don't follow me. Do what you do. What's his name on here, Nikki? judge need to be for. Yeah, Judge Glanville need to be put under judicial watch. Definitely. Hold on. Now he got YSL and MAGA on it. I knew it was coming. He got YSL and MAGA on it. That's right. Here we go. We won't be stopped, baby. MAGA stick together. I wish some of us would. Dang. And his daughter isn't. Oh, Jesus Christ. Hold on. Wait a minute. Somebody said something. I'm trying to find it. This thing's moving too fast. I remember it was only 200 people in here. Now here come all these new people. Today was insane. Judge was lost and Miss Love's big booty. Oh, wow. Still trying to make child time. People going to be outside the court today boycotting. Yeah, that might happen. I know we're way past this, but I almost lost my mind when Woody said, "Hey, Judge, hot. I can take this up." Yo, wow, yo. Everybody's guilty. Foodie world. Let's say. So I can't even see no. It's been almost 30 minutes since he said 5 minutes. Oh yeah, it's gonna be ugly. He only said 5 minutes so we wouldn't get mad. He should say the right thing. Give me an hour and I'll be back. What the F is the judge doing? Hurry up and let Mr. Steele free. Man, this gonna make Steele, boy. Jesus Christ. Steele ain't playing. They said the judge in the chambers reading the comments. Oh, okay. Whatever. Yeah. Colton is Squire World. What's going on? What's going on, Colton? Wow. Judge gonna come out and plead the fifth in 5 minutes. Guess we supposed to stay tuned in until tomorrow. Judge not coming back in front of the world today. Cleveland Teddy. It's what we call a closed case. Steele for president. It's going to be a long morning tomorrow. Judge not about to get any rest. Yeah. He needs some milk. This made breaking news. Twitter, Instagram, TikTok, and Facebook went viral, y'all. Shh, I bet it did. So as we wait for the judge to come out and we just having conversation and we read the chat, you know what I mean? Share it out with everybody, man. Share me out. But I'm on Twitter too. Share me out on Twitter. Like, share, subscribe. And we building over here. Let's grow. Let's grow. Let's grow together. I just sent the message to, hold on, but I'm so jealous, man. The lead attorney got 8.2 thousand people watching him, man. This is crazy. I'll get there one day. When I have 8.2 thousand watching me. That's it, Busy Mom. Free Thug and his lawyer. Mm. Man, we on watch right now. I know his stomach might hurt. Euro is the judge first name. You know what that is? You know what? That is Glanville's first name. Damn, that is his first name. You're right. The judge is on the phone with his white zaddy. You stupid, Judah. You stupid. He may be on the toilet trying to get rid of all that bull crap. I have a few questions about you too, Dana. I'll call you. Cool. Okay, Nikki. Right here, Nikki. Hold on, I see it. Keeping it real with Dom K. And he stole Alicia's name. Yeah, I see. Oh, man, he stole Alicia's name. Keeping it real with Alicia Podcast TV. Yo, the dream team is awfully imitated, never duplicated. Hold on. Jerron Perry said, hold on. Hold on, let me see. Jerron Perry said, bad. Basically, still got the Georgia Bar Association outside. Man, run, dog, run. Run, Jesus. Oh, my God. Jesus Christ. Fox 5 got 5,983 people watching. I got 83 people watching. I'm jealous. Let's get it back to where we used to have it. Where we had like 400 in a chat, 500 in a chat. Let's get it back though. I can't believe Mr. Copeland admitted to killing Peanut. Look, see? See what I told you? This is nothing about gang. This is about Peanut. I thought Steele said that before the judge cut him off. You thought Steele said what? Yeah, I see all the R. Kelly folks over there in Fox 5.
Attention, did you serve, live, or work
Hold on,
at Marine
what
Corps
happened?
Camp Lejeune, North?
Hold on. I'm about to say, what? No commercial breaks. So all this time, Steele could have shut this shit show down with one phone call. Man, look. This is crazy. I guarantee you this is going to be a TV show. Watch. Euro said, no room, Ashley. Like people can sit in a juror box, still seats in the back. Euro mad about that. Yo, they are really getting on him. Oh boy, yep. Atlanta is not a real place. I've been telling y'all this, man. It's only good for one thing, and that's entrepreneurship. I must give this to Steele. He just showed us he is not to be played with. We say Steele said he the real YSL. Steele has pulled like no other 25 plus attorneys pulled up in his defense. That's loyalty. Yeah. I ain't blocking nobody. I don't know what I come for. Bet he comes back and it says, nope, he stays. But he come back and said, nope, he stays. I found the law in 2055. That says right here, I can do this in the future. And nobody is the future. Yeah. Yeah, I got connected to the courthouse. Told you. Yeah, nigga, I got connects. I'm actually talking to three of them right now. Yo, everybody loves Steele. And once again, that's Donald Trump's lawyer. That's Trump's first choice. I'm loving this. Mm, mm, mm. Wow. Yo, it's been literally 25 minutes and he haven't came back. Call them and have them do a mental health check. All right, hold on. Something must be going on, Nikki, because ain't nobody answering right now. And one of them just texted me, was like, yo, hold on, yo, we outside the courtroom. So hold on, I'm trying to figure out right now. Hold on, I'm trying to get a response. Up. I got the first picture. Hold on. Hold on. Hold on. Hold on, y'all. Ooh-wee. God. That's what I'm talking about. Stand on business. Hold on, y'all. Everybody on the Instagram. If it cut off on y'all, just come on over to YouTube or go to Rumble. Hold on. I got the first picture. If y'all want to know what it looked like outside of Judge Glanville's office, put hell yeah in the chat. If y'all want to know what it looked like outside of Judge Glanville's office, put hell yeah in the chat. If y'all want to know what it looked like outside the Glanville office, put hell yeah in the chat. Now, I ain't going to show it unless y'all put hell yeah in the chat. God damn. I ain't know. Let me shut up, Dana. Dana, shut up. I ain't know Ashley was that thick. God, Jesus. Jesus. I only got 2 hell yeahs. No, that's not going to work. That's not going to work. If y'all want to know what it looked like outside the courtroom, or why Judge Glanville ain't come back, hold on. I got 1, 2, 3, 4, 5, 6, 7, 8. All right. I got 8. Yo, I need 15. I need 15 because it's not a lot in here, so I need 15. If y'all want to know what it looked like outside of Judge Glanville office, you got 7. 7? Hell no. Look at this. Let me see. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Got 10. 10. I need 5 more people. 5 more. I need 4 more. 4 more. I need 4 more people because I got the picture sitting right here. No cap. No cap. I need 3 more. I need 2 more. I need 2 more. It ain't no time to be saying hey to nobody, and we trying to get this petition going. If y'all want to know what it look like outside that bad joint, this is why he ain't come back out yet. This is why. Man, if I see that, I'm not coming out neither. This is why. You done played with the wrong person. This is why. The whole hallway full of lawyers. But I ain't gonna lie, Ashley, Jesus Christ. Woo. 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 Steele right there chilling. Ashley Merchant right here. You got the president right there. Now, when you start getting dinosaurs come out, Lord have mercy. When you start getting the dinosaurs come out, you know it's a problem. Listen, I got a question. Why can't we come out like that for our own? Saying stuff like this motivate me. She went in like a beat. Kiva, she's like that 24/7. She's like that 24/7. And she's such a sweetheart. Ashley Merchant is such a sweetheart. But this is what he's facing. And honestly, him, this one right here, Colton, this is who he don't want to see. Because he's the chair of Georgia's Bar Association. This one right here is the chair of Georgia Bar Association. Whew. So now Glanville looking like his license might be on the line now. And he still haven't came out. I mean, if you scared, say you scared, bro. Look at this. I'm going to get y'all up close. Look at this. Look at this. Look at this. This is wild. You got all the attorneys out there from the Bar Association, including the chair. I mean, but the head. Love need to go. Definitely. Lexington said, boy, if she would have been there when Ann Donnelly was with that. But listen, man, see, it's so much I can say and so much I can't say. You know what I mean? It's so much I can say and so much I can say. There's so much I can say and so much I can't say. You know what I mean? I just wish people would have listened to me from the jump. But, you know, it is what it is. Like I say, I got the first picture. I'm the first one on YouTube that dropped the picture. First one of this hallway. God damn, you still ain't come out yet? Boy, his stomach probably, ooh. His stomach probably hurting. Oh, hold on. They sending me these pictures like crazy. Hold on. Hold on. Hold on, y'all. I got one coming in hot. Hold on. Attach. Send. Okay. I've been on for 4 hours now. Nobody expected for this to take a turn like this. Nobody expected it. Here we go, Dream Team. Oh my God. And he said he didn't want them in there. But ain't nothing he can do now. They're in there. And there's more outside. So you got 30 something outside and you got 22 sitting right here. Lord have mercy. Jesus Christ. And if you pay attention, it's from every walk of life. Wow. Glanville, you started some shit now. Mark my words, Young Thug case is going to be a case law. Watch. This is wild. Come, Glanville, come on, man. What happens? Come on. Listen, I'm going to stay here as long as it takes. I ain't taking no breaks. I ain't taking no shortcuts. I'm staying here as long as it takes. Also, y'all, I got a poll up. Y'all go ahead and take a look at that poll. I got a poll up, but I'm going to stay here as long as it takes. Exactly. They are going against the system, and they planned it real good. Yep. Man. Hold on. I'm about to switch over. To ANF. That's what I rock with anyway. Atlanta News First. There's 14,000 more people on another channel watching, so we're not the only ones waiting around. Extortion. The Drip family. Judge is taking time to dig his way out from getting caught. The judge is a straight up hateful man. He is doing whatever it takes for the prosecution to win this trial. What a mess this is in front of the world. Hold on. All right, hold on. Here we go. Here we go.
All right, thank you, madam.
Here we go.
It's what we use in our bonds.
Sergeant Brown, is everybody present? Needs to be present? All right, thank you for your patience, counsels. The court's had an opportunity to reflect, and Mr. Steele, if I could ask you to take the podium, please, as well, and stand next to your attorneys. Okay, Ms. Merchant, Mr. Steele, and I apologize.
Mr. Susar, Judge.
One more time?
Susar.
What, spell your last name for us?
S-U-S-O-R, Sierra, Uniform, Sierra, Oscar.
You're a good man. Good man. Okay, all right. Okay. All right, thank you, sir. Okay, Mr. Susar as well. All right, counsels, I've made a clarification or to the order of contempt. Mr. Steele, I am going to hold you under, still hold you in summary criminal contempt pursuant to OCJ 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays.
What?
And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024 at 7 p.m., subject to further order of this court. And that will be entered and e-filed. You may take whatever steps you and your counsel deem appropriate after that. Okay?
Can I ask a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will, if that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay? If that should occur. Okay? All right. Okay. All right. All right. Is Miss counsels, I'm done with this unless you have anything else. All right. Thank you. Thank you, Miss. Thank you, Miss Merchant and Mr. Susar. Thank you. Okay. All right.
He just sealed his. He just sealed his fate.
Yes. In fact, the clerk is going to file a copy. It's going to be e-filed. It'll be on the e-file system momentarily. You should be able to get a copy of it from there directly, download from there.
And Judge, Ms. Merchant and I will file entries of appearance on behalf of Mr. Steele.
Sure, that would be great. Thank you so much.
Oh God.
Okay. All right. All right. State, is there anything else that we need to, or any defendants, is there anything else we need to take up before tomorrow morning? Mr. Copeland is going to rejoin us tomorrow morning, so we'll continue with his testimony. Where's Miss Bumpus?
I have a matter.
1 second. Where's Miss Bumpus? She hasn't been released yet.
I'm not certain, and Ms. Hilton is attempting to determine her whereabouts.
All right, if you could call her, Miss Hilton. Thank you. All right, Mr. Sharp, sir?
Your Honor, I have to prepare for my cross-examination of Kenneth Copeland over the next few evenings, and I would ask once again for the court to release the transcript of what occurred earlier today so that I may prepare my cross-examination.
I'm not going to do that, sir. Not at this point in time, respectfully.
Wow.
Well, Your Honor, respectfully, and if it's not released by the time that we cross-examine Mr. Copeland, our defense will be hindered.
Sir, that will be an issue you can certainly raise then and now, but I'll think about it. But at this point, I'm not inclined to release the transcript of the court's ex parte hearing.
No, because he's going to try to fix it.
It was the way it was disseminated. That's why I'm not inclined to do it.
And I would also, I understand the court's ruling. I would also ask for the release of any audio tapes regarding that hearing as well.
Well, the only audio tape that I know of is maintained by Miss Weaver, who tapes her proceedings in order for her to prepare a transcript. So, okay. Well, I don't know. She may not have any, but we'll see. Okay.
Good evening, Carson Matthews, on behalf of Mr. Steele. We were making that same request, Your Honor, for that transfer review potentially could contain some grave.
Sure. Okay. All right. Unless there's anything else, counsel?
I join that, and I also believe I advise the court the reason that I also want for confrontation cross-examination is supposed admissions Mr. Copeland made about our case outside our presence, and based upon information and belief, the court handed Mr. Copeland allegedly the long false swearing and perjury, and if that's true, I'd like to also talk with him, if he'll talk, about how that came about. I'd like to read the transcript. So I'm joining in, but also it goes to matters that are discussed about the case based upon information.
Madam.
Your Honor, there was no matter to which either counsel for either of the defendants was a party. There was no matter to which either defendant in this case was a party that was had or held outside this courtroom. So we would ask that the court deny what is being requested of the court, because that is something to which neither
Oh no.
is entitled.
Oh no. Oh, you can't have a secret meeting.
All right, sir.
Wait a minute. Dana, the judge, continued the contempt of court. Okay.
Your Honor, I would additionally point out that the question to which Mr. Copeland asserted a Fifth Amendment privilege was, how old are you?
On Friday.
Yes.
Yeah. All right. I'm going to deny your motion, at this time, Mr. Matthews.
Your Honor, I don't understand the state's argument that we are not a party. This gentleman was sworn in as a witness against all of our clients. He is sworn in as a witness specifically against Mr. Stillwell. Conversations with that gentleman were occurring apparently ex parte without our knowledge, without my client's presence. And I don't understand how the state with a straight face can possibly say we are not a party to matters concerning a witness sworn in trial to testify against our clients. We are certainly a party.
Okay.
And we were denied the right to be present.
All right. Thank you, sir. I'm still going to deny it. All right. Anything else?
Yo, this is corrupt. This is corrupt.
It's an ex parte matter, so you're not going to get it unless the unless the appellate court wants to see it if it's accepted. So, but I'm not going to give it to you at this point in time.
Hold on, time out. Why do he keep talking about the appellate court? Once again, this case is already decided.
Yes, sir. All right. All right. See y'all tomorrow morning, okay? 9:30 for an anticipated 10 o'clock start time? Okay, we're in recess.
Okay, this is what I'm gonna do. See, I wasn't even gonna go this route. But here's what I'm. If you want to call in, call in. Let's talk about what we just witnessed. Hold on. All right. If you want to call in 404-914-7986. Let's talk about it. Let's talk about it. Let's talk about it. 404-914-7986. Let's talk about it. Go ahead and call in. Express your concerns, express your likes, express your dislikes. I'm here. Call in. Yep, still got a great lawsuit, Michelle. But like I say, call in. If you want to talk about it, call in. If not, then I'm going to get up off here. I'm going to hold a little while longer and see if anybody call in. If not, then I'm getting up off here. I'm trying to see if anybody want to call in and express their concerns, likes, dislikes, angers, whatever. And hit that like button. Like, share, subscribe. Let's turn up. Let's turn up. Like, share, subscribe. Well, I ain't going to hold y'all, and I ain't going to hold the people waiting. I'm about to get up off here. This was the YSL joint. I had something else planned, but then that happened. So I had to bring it to you. So guess what? Tomorrow evening, I'm going to drop the beginning of the Joe Biden Creepy Joe situation. Okay? And I'm going to start bringing you points from the opposite side of the tracks that don't rock with the Biden administration or the Democrats. Okay? So check this out. You don't have to be great to get started, but you have to get started to be great. Be someone important. Be yourself. And until tomorrow, guess what? We out. Peace.
The spices are in. The spices are in. Oh my God. We got Dana J. Hattie Lemon Steak Spice. Oh yeah. We got the Dana J. Lafayette Low High Rise Tropical Bang. Come and get it. We got the Dana J. Lafayette White Dirt, y'all. We got the Dana J's Jackson Family Seafood Blend number 2. Oh my God. Then we got Dana J's Lemon Family Seafood Blend number 1. We also have the Dana J's Lafayette Low Rise Mild Heat. If you know if you want that heat. Then we got the real heat. If you want the Dana J's Smut. That's the extreme heat that got the Joker on the side. Oh my God. Come and get it. Come and get it. The Dana J spices are running wild. I'm telling you, come and get it. After you taste these spices, you ain't gonna want nobody else's. I holler at you later. Hit me.
Swimming in you. Hey, little mama. Said I wanna take her. Dip in your pool. Just go for a little dive there. Hey, yeah, yeah, yeah. Sometimes a misty rain that gently touches my soul, feels just like fire shut up in me, yeah. Simply lose control. Let your love just fall like raindrops.